Convention, number 98, concerning the application of the principles of the right to organize and to bargain collectively, done at Geneva on 1 July 1949, entry into force, 18 July 1951. Preamble. The General Conference of the International Labour Organization, having been convened at Geneva by the governing body of the International Labour Office, and having met in its 32nd session on 8 June 1949, and having decided upon the adoption of certain proposals concerning the application of the principles of the right to organize and to bargain collectively, which is the fourth item on the agenda of the session, and having determined that these proposals shall take the form of an international convention, adopts this first day of July of the year 1949 the following convention, which may be cited as the Right to Organize and Collective Bargaining Convention, 1949, Article 1, 1. Workers shall enjoy adequate protection against acts of anti-union discrimination in respect of their employment. 2. Such protection shall apply more particularly in respect of acts calculated to a. Make the employment of a worker subject to the condition that he shall not join a union nor shall relinquish trade union membership, b. Cause the dismissal of or otherwise prejudice a worker by reason of union membership or because of participation in union activities outside working hours or, with the consent of the employer, within working hours. Article 2, 1. Workers' and employers' organizations shall enjoy adequate protection against any acts of interference by each other or each other's agents or members in their establishment, functioning or administration. 2. In particular, acts which are designed to promote the establishment of workers' organizations under the domination of employers or employers' organizations, or to support workers' organizations by financial or other means, with the object of placing such organizations under the control of employers or employers' organizations, shall be deemed to constitute acts of interference within the meaning of this article. Article 3. Machinery appropriate to national conditions shall be established, where necessary, for the purpose of ensuring respect for the right to organize as defined in the preceding articles. Article 4. Measures appropriate to national conditions shall be taken, where necessary, to encourage and promote the full development and utilization of machinery for voluntary negotiation between employers or employers' organizations and workers' organizations, with a view to the regulation of terms and conditions of employment by means of collective agreements. Article 5, 1. The extent to which the guarantees provided for in this convention shall apply to the armed forces and the police shall be determined by national laws or regulations. 2. In accordance with the principles set forth in paragraph 8 of Article 19 of the Constitution of the International Labour Organization, the ratification of this convention by any member shall not be deemed to affect any existing law, award, custom or agreement in virtue of which members of the armed forces or the police enjoy any right guaranteed by this convention. Article 6. This convention does not deal with the position of public servants engaged in the administration of the state, nor shall it be construed as prejudicing their rights or status in any way. Article 7. The formal ratifications of this convention shall be communicated to the Director General of the International Labour Office for registration. Article 8, 1. This convention shall be binding only upon those members of the International Labour Organization whose ratifications have been registered with the Director General. 2. It shall come into force 12 months after the date on which the ratifications of 2 members have been registered with the Director General. 3. Thereafter, this convention shall come into force for any member 12 months after the date on which its ratification has been registered. Article 9. 1. Declarations communicated to the Director General of the International Labour Office in accordance with paragraph 2 of Article 35 of the Constitution of the International Labour Organization shall indicate, a. the territories in respect of which the member concerned undertakes that the provisions of the Convention shall be applied without modification, b. the territories in respect of which it undertakes that the provisions of the Convention shall be applied subject to modifications, together with details of the said modifications. C. the territories in respect of which the convention is inapplicable and in such cases the grounds on which it is inapplicable. D. The territories in respect of which it reserves its decision pending further consideration of the position. 2. The undertakings referred to in subparagraphs A and B of paragraph 1 of this article shall be deemed to be an integral part of the ratification and shall have the force of ratification. 3. Any member may at any time by a subsequent declaration cancel in whole or in part any reservation made in its original declaration in virtue of subparagraph B, C, or D of paragraph 1 of this article. 4. Any member may, at any time at which the Convention is subject to denunciation in accordance with the provisions of Article 11, communicate to the Director General a declaration modifying in any other respect the terms of any former declaration and stating the present position in respect of such territories as it may specify. Article 10, 1. Declarations communicated to the Director General of the International Labour Office in accordance with paragraph 4 or 5 of Article 35 of the Constitution of the International Labour Organization shall indicate whether the provisions of the Convention will be applied in the territory concerned without modification or subject to modifications. When the declaration indicates that the provisions of the Convention will be applied subject to modifications, it shall give details of the said modifications. 2. The members or international authority concerned may at any time by a subsequent declaration renounce in whole or in part the right to have recourse to any modification indicated in any former declaration. 3. The members or international authority concerned may, at any time at which this convention is subject to denunciation in accordance with the provisions of Article 11, communicate to the Director General a declaration modifying in any other respect the terms of any former declaration and stating the present position in respect of the application of the Convention. Article 11, 1. A member which has ratified this Convention may denounce it after the expiration of 10 years from the date on which the Convention first comes into force, by an act communicated to the Director General of the International Labour Office for registration. Such denunciation shall not take effect until 1 year after the date on which it is registered. 2. Each member which has ratified this convention and which does not, within the year following the expiration of the period of 10 years mentioned in the preceding paragraph, exercise the right of denunciation provided for in this article, will be bound for another period of 10 years and, thereafter, may denounce this convention at the expiration of each period of 10 years under the terms provided for in this article. Article 12, 1. The Director General of the International Labour Office shall notify all members of the International Labour Organization of the registration of all ratifications, declarations and denunciations communicated to him by the members of the organization. 2. When notifying the members of the organization of the registration of the second ratification communicated to him, the Director General shall draw the attention of the members of the organization to the date upon which the convention will come into force. Article 13. The Director General of the International Labour Office shall communicate to the Secretary General of the United Nations for registration in accordance with Article 102 of the Charter of the United Nations full particulars of all ratifications, declarations and acts of denunciation registered by him in accordance with the provisions of the preceding articles. Article 14. At such times as it may consider necessary, the governing body of the International Labour Office shall present to the General Conference a report on the working of this convention and shall examine the desirability of placing on the agenda of the conference the question of its revision in whole or in part. Article 15, 1. Should the conference adopt a new convention revising this convention in whole or in part, then, unless the new convention otherwise provides, a. The ratification by a member of the new revising convention shall ipso jure involve the immediate denunciation of this convention, notwithstanding the provisions of Article 11 above, if and when the new revising convention shall have come into force. b. As from the date when the new revising convention comes into force, this convention shall cease to be open to ratification by the members. 2. This convention shall in any case remain in force in its actual form and content for those members which have ratified it but have not ratified their revising convention. Article 16. The English and French versions of the text of this convention are equally authoritative.